government's argument is they looked at the 2018 guidance and they argued repeatedly with a straight face the Bank Secrecy Act does not require custody or control of funds to apply. It turns out that was wrong. So the question is, did they essentially lie to the judge or mislead the judge in some way about what they understood the guidance to mean? Or did they not know? Both of those seem really bad.
Welcome, everybody. I'm Frank Corva, the political correspondent here at Bitcoin Magazine, and I'm joined by Zack Shapiro, managing partner at Rains Law, as well as the head of policy at the Bitcoin Policy Institute. And we are here this evening to discuss a bombshell development in the Samourai case. So, Zack, welcome. Thank you so much for taking the time to join us.
Thanks for taking the time to talk to me.
Pleasure's all mine. We've been in the Samourai courtroom together. We've been following this case closely. Please bring us up to speed on what's going on.
Absolutely. So, the first big development, I think, to talk about happened on April 7th of this year when the Deputy Attorney General of the United States, Todd Blanch, issued a memo now called the Blanch memo, talking about enforcement priorities for the Department of Justice with regard to digital asset related cases. And the centerpiece of this Blanch memo is that the department is no longer going to engage in regulation by prosecution or regulation by enforcement, right? The idea is that in the American government system, we have three branches of government and each plays their own role. We have the legislative branch, Article 1 in the Constitution. Their job is to make the laws that we all abide by. You have Article 2, which is the president, the executive branch. Their job is to enforce the laws that Congress wrote. And then you have Article 3, which is the judiciary. Their job is to interpret the law when that's necessary and to help decide disputes. What you don't want is the law enforcement arm of the executive branch deciding that they are going to make new rules, and instead of having a notice and comment period like you would have with a regulator, instead of having a vote like you would have with a statute that goes through Congress, they put people in jail and that's how they tell you what the new rule is. And unfortunately, the digital asset industry faced a lot of what at least felt like and what we discussed as regulation by enforcement with the prior administration. So this happened with securities laws with crypto, but it also happened really meaningfully with two criminal prosecutions that affect the way the Bank Secrecy Act applies to non-custodial software, one being the Tornado Cash case and one being the Samourai Wallet case. And, very briefly, FinCEN, which is a part of the U.S. Treasury Department, which oversees illicit finance risk, they have a licensing regime that applies to what are called money service businesses. Money service businesses are regulated financial institutions, most commonly banks, but also ATM operators, remittal businesses, etc. And they have to register with FinCEN and get state-by-state licenses to make sure that they are carrying out the AML KYC requirements of the Bank Secrecy Act. And FinCEN had put out guidance first in 2013 and then again in 2019, specifically regarding Bitcoin and Bitcoin-related tools and laying out what business models they think constituted a money service business and were therefore subject to the Bank Secrecy Act and which were not. And the understanding of most lawyers that looked at this through the 2019 guidance, which is the last time FinCEN spoke on the subject, is that the line between who the Bank Secrecy Act applied to and who didn't had to do with whether you had custody or control of user funds. So if you're a custodial exchange like Coinbase, you're a money service business, right? Because people give you the money and you take it and then you give them other money. You're a money transmitter. However, if you're just writing software, if you're develop a non-custodial wallet that allows people to generate a seed phrase that allows them to hold their own Bitcoin, of course, you're not a money service business and you're not obligated to KYC your users because how could you? You just published a piece of code that people are using to store and send their own funds on the Bitcoin blockchain. What was notable about these cases is for the first time in Tornado Cash and then again in the Samourai Wallet prosecution, the Department of Justice, which is different than FinCEN, the Department of Justice is the federal prosecutors that bring criminal cases, tried to imprison software developers for developing and then offering non-custodial software tools that people use to move their own funds, Ethereum in the case of Tornado Cash, Bitcoin in the case of Samourai Wallet. And the central issue in both of these cases is, does the Bank Secrecy Act require you to be in control or custody of other people's funds in order to be subject to the requirements and therefore at risk of criminal prosecution if you don't follow those requirements. So in the Blanch memo, they said, we're not going to bring any more of these cases. It's not up to the Department of Justice to decide how the Bank Secrecy Act applies to non-custodial tools or not. FinCEN can weigh in, but ultimately this is a statutory question, and federal prosecutors shouldn't be in the business of deciding that. That's not how our democracy is supposed to work. A couple days after that, on April 10th, the defense lawyers in the Samourai Wallet case requested an adjournment of the briefing that was happening in this case leading up to a motion to dismiss, so the parties could discuss whether under this new policy from the Department of Justice, which squarely said that the Department of Justice would not bring what's called Section 1960 prosecutions, which is prosecution for unlicensed operation of a money transmitter business. The government would decide whether they want to drop this case because it's now inconsistent with the memo. Now, a month later, the defense counsel have discussed with the prosecutors. The prosecutors have not given any answer. You'd think that something that would fall squarely in the middle of this memo, it wouldn't take them that long. But a month later, there's no answer from the government. And we just got this new bombshell development today, publicly filed, that says I think it's about a week ago, in response to what's called a Brady request. So Brady is a Supreme Court case that says if you're the government and you're prosecuting someone and you have exculpatory evidence, right, you are aware of a fact that maybe the defense doesn't know that makes it more likely that the person being prosecuted is innocent of the crime as opposed to guilty, you have to turn that over to the defense as a matter of due process under the Constitution. What we learned is that in response to a specific Brady request, which is the defense asking the prosecution, hey, do you have X, Y, and Z things which we think are exculpatory? One of the things they asked is, have you talked to FinCEN about, does FinCEN think that Samourai Wallet is a money transmitter? That did happen. The prosecutors in this case, the ones who are currently prosecuting the developers of Samourai Wallet, in August of 2023, went to FinCEN to talk to them about whether they wanted to bring this case. FinCEN said in no uncertain terms, Samourai Wallet is not a money transmitter because under the FinCEN guidance, in order to be a money transmitter, you need to have custody or control over user funds. And that is undisputedly not the case with Samourai Wallet, how it worked. And therefore, in FinCEN's view, you could not bring 1960 charges against Samourai Wallet based on that theory. Prosecutors ignored that. 6 months later, they brought the indictment in this case. They arrested the defendants, the developers of Samourai Wallet, and they didn't mention for the first 6 months of the case that they knew that FinCEN did not believe that Samourai Wallet was a money transmission business, despite the fact that that is sort of the central contention of the criminal prosecution. So the fact that this comes out now is sort of incredibly shocking, should upend the case. And I really think should spur outrage among everyone listening to us now, and hopefully also in the Department of Justice, which I think is being pretty openly flouted by continuing to bring this prosecution that I think there's no way to understand now other than regulation by criminal prosecution.
Can we put this in context a little bit? So does this happen often to your knowledge? So is this something that's very out of the ordinary where a prosecutor would proceed despite being given a message from the DOJ or from FinCEN saying, no, there's nothing they've done wrong here, but we're going to proceed anyway? Is this common or is this very, very irregular?
Yeah, so the truth is this type of case is already very irregular, right? The Department of Justice usually doesn't bring prosecutions that require really novel theories about cutting edge technology. That's an irregular fact pattern. Now, you would think that in a case where the whole point of this case, right, this is a pushing the envelope case, and the central charge in this case is that the defendants illegally operated an unlicensed money transmitter business. And what does unlicensed mean? It means they didn't get a license from FinCEN, and FinCEN is the regulator that decides who is a money transmitter in their guns under the Bank Secrecy Act. You'd think they'd ask FinCEN. So I would say that the combination of these circumstances, at the very least, is extremely unusual and disturbing.
Okay. What do you think was motivating the prosecutors then? Was it the climate under the Biden administration of attacking open source devs, of attacking crypto more broadly? Is that the primary motivation in your mind? Was it coming from someone above them saying, no, we're sort of going to move forward with this regulation by enforcement and policy come hell or high water, and this is just more people in our way, and we're just going to move forward despite the fact that there's really no logical reason for us to do so?
So we don't know the answer to that, right? So far as I know now, I don't think that the primary motivation was to, go after and ban crypto, as opposed to, for example, there's a proposed bill from Elizabeth Warren called DAMLA, the Digital Asset Anti-Money Laundering Act, which has the same effect of this prosecution. It labels basically all of the actors in crypto, whether you're a node runner, a miner, software wallet developer, whatever. They're all money transmitters, even though she knows full well they can't comply with that, and therefore it's a crypto ban. I don't think that's what the prosecutors were up to, although I do think this would be an appropriate subject for a Brady request now that we know that the prosecutors ignored FinCEN. Did they get any political directive from the White House, from anyone in the Senate, anything like that, that might have motivated that? I think that's a completely fair question to ask at this point. But whether or not the answer to that is yes, I think it does need to be understood against the backdrop of the digital asset industry, and Bitcoin in particular seem to be sort of a disfavored class in the previous administration. And, there was just a very different environment between the federal government, specifically the executive branch, and the industry as a whole. And it's very hard for me to imagine that this case could have been brought at all in this administration, especially post the Blanch memo, which we just talked about, which explicitly forbids the Department of Justice from bringing these types of cases. So it's relevant even if it wasn't the motivating factor. What I think the motivating factor more likely is just a frustration with money laundering happening through digital assets, including Bitcoin. And no doubt that does happen. It is a small minority of the throughput of the Bitcoin network, but it does happen. And then sort of a casual disregard for the collateral damage of bringing a case like this, while focusing on the upside of, okay, if we absent non-custodial tools from our enforcement regime, maybe this becomes a big loophole. And so I think they were probably more focused on the ability to bring and win money laundering cases than they were on, is this good policy? Is this a rational thing to say about the tool that money transmission even happened as just a logical matter? And then, does this stifle innovation and chill speech?
Okay. In the case of Samourai, does the whole case in your mind now get thrown out? Because there were two charges. One was the conspiracy to operate, I believe, an unlicensed money transmitter business. And then the other one was the conspiracy to take part in money laundering, if I'm not mistaken. Maybe you can clarify exactly what the two charges were and whether you think both will be thrown out as a result of this.
Yeah, absolutely. So the two charges in this case, the first, as you say, is operation of an unlicensed money transmitting business. Unlicensed, again, means licensed with FinCEN. Money transmitting business means under the Bank Secrecy Act that you accepted and transmitted funds on behalf of the public. If it sounds like that means that you needed to have custody of those funds in between accepting the funds and transmitting them, well, I agree with you, and I guess we know now so did FinCEN. But nevertheless, the government says that by offering this software, somehow not Samourai's users, but the Samourai developers were transmitting their users' money to which they didn't have keys. And then the other charge is conspiracy to commit money laundering. So conspiracy requires people to come together to agree to intentionally do something. So you need a underlying criminal act, whether that's unlicensed money transmission, whether that's sanctions evasion, whatever crimes people are committing, and then you needed people to conspire to help hide the proceeds of those unlawful acts. What effect will this revelation have on each of those charges? I mean, I would think that it makes it really hard to maintain the unlicensed money transmission charge, right? I think it would be a real miscarriage of justice and travesty if they allow that charge to go forward, because in addition to proving the activity in question, right? Did they, engage in unlicensed money transmission? Well, FinCEN thinks no. Logic, I think, would dictate no, et cetera. Even if you disagree with FinCEN on that, which would be a weird position for the DOJ to be in, you still also need to prove mens rea, right? Mens rea is a Latin word for the defendant knew that they were doing something wrong, right? If you are on the subway and someone bumps into you, and because someone bumped into you, your body hits someone else's body, they can't sue you for assault. You didn't try and do it. You were just a body in motion there. And so you have to prove that the defense knew they were doing something illegal. You don't necessarily need to prove that they knew it was illegal, but they need to know they were doing some sort of illegal activity. And here we know that their lawyer, right, counseled them that what they were doing was illegal. It was outside of money transmission. The Brady letter today actually cites a couple of instances where the defendants here went on podcasts and they talked about the distinction between their business and what they understood to be money transmission. And FinCEN, the body that they were supposed to get a license from, clearly thought that this wasn't money transmission. So if you imagine, if they had taken a different view and they'd gone to FinCEN and said, okay, we're here to register, FinCEN would have said, actually, no, you can't register with us. So tagging them criminally with not registering doesn't make any sense. There's also a related argument about fairness and due process and notice that they were violating the law. I think it makes it really untenable in light of this to continue the money transmission charges, but we will see. Ultimately, that's up to the prosecutors and the judge and the Department of Justice. The other charge I think just is harder to prove in the absence of the first charge, right? You have to show that these individuals conspired to actually help people launder the proceeds of crime. That is a factual matter. You have to, again, prove their mens rea. There might be some smoking gun evidence that we don't know about, but, I think we would have heard about that by now. And then, to the extent that these charges are linked, right, that some of the money laundering charge has to do with the fact that these guys knew they were operating an unlawful business. That can't stand without the unlawful business. So I think the charges are linked together. Could there be a scenario where one goes away and the money laundering charge stays and goes to trial? That is possible. But who are the decision makers? So right now, the federal prosecutors are deciding whether what they are doing is consistent with the Blanch memo or not. So they could make that decision. A lot of the discussion on Twitter so far today has talked about a Brady violation. As a very technical legal matter, there has not yet been a Brady violation. It's a Brady violation when you do this after trial. As long as you disclose before trial, it's not technically a Brady violation, even if it's terrible practice under Brady to wait this year. What it is, though.
Could I clarify there? So just to make, so you're saying that on the part of the prosecutors, they didn't necessarily take part in what you just described as a Brady violation because they would have had to have happened once they were at trial already. Just to clarify.
Yeah. So Brady itself is the Supreme Court case that really talks about what happens if someone goes through trial and you haven't given them the exculpatory information. However, there is Criminal Procedure Rule 5F, which allows a judge to say, listen, in my courtroom, because of due process, you have X amount of time to give Brady information, right? Whatever Brady says, these are the rules in the court. And the judge in this case had a rule that you had to give it within 2 weeks of knowing it or of the indictment. And so that appears absolutely violated. Now, the prosecutors could say, this is not exculpatory information. We can take a different view of money transmission than FinCEN. For the reasons we've talked about, I think that would be a ridiculous thing to say. But I think it is quite clear, at least in my view, that this is a 5F violation. And as a 5F violation, that then gives the judge an opportunity to intervene here. And the remedies, what the judge is allowed to do here in response to a 5F violation, are quite broad and at the judge's discretion, but they range from doing nothing. It could be a slap around the wrist. You could individually sanction the attorneys, right, for withholding this information against the court's rules, or you could go up to dismissing the charges. So the judge could also get rid of this case now if the judge so chooses. And then the other, I think, relevant actor here, right? If you're the Trump administration, right, you're coming in and, you want to be friendly to digital assets. President Trump has been remarkably clear about that and said that over and over again and taken many actions from executive orders to ending lots of lawsuits by the SEC to helping provide regulatory frameworks that show that he wants the United States to be the capital of innovation and a Bitcoin superpower and all of these wonderful things. In light of the Blanch memo, I also wouldn't be surprised if the administration or the Department of Justice, so Department of Justice, you have Main Justice, which is in D.C., and then you have the U.S. Attorney's Office, which are like the mini law firms, the government in each of the federal districts. And so the one here is the Southern District of New York, which covers Manhattan, the Bronx, and parts of Westchester. You could have Main Justice step in and say to the prosecutors, listen, this just is, you've had your time to think about it, but actually this is just not consistent with the administration's policy. It's not consistent with the Blanch memo, and you guys really need to shut down this case. So all of those are possibilities, and they could get rid of both of the charges or get rid of just one. I think at this point, the right thing to do is get rid of both.
Okay. I read something in the email you sent out today about this. The judge, I have my notes here, so the prosecutors... I think it's that they told Judge Berman that they're considering dismissal. Do I have that correct?
Yes.
Could you touch on that a little bit?
Yeah. So the Blanch memo came out April 7th. On April 10th, defense counsel wrote to the government, said, "Hey, we think this falls under the Blanch memo. We think you should drop the case." Both parties agreed to a pause of the pretrial proceedings so they could discuss it, and the government agreed in their letter to the court that they are considering whether or not to keep these charges going in light of the Blanch memo. So that's what's going on now, but that's been going on for a month. And again, if you read the Blanch memo, if the Blanch memo isn't about this case and about Tornado Cash, what is it possibly about, right? Like, I think this is really at the heart of the Blanch memo. So the fact that it's been a month and they've not been able to make up their mind, I think signals that the prosecutors really don't want to give up this case, and they might need an external push, whether that's from the judge or whether that's from the Department of Justice, from Main Justice.
I think I've had some conversations where some people have talked about the Blanch memo, saying that, okay, from here on out, we're not going to do that anymore, but maybe the case, maybe Samourai would have lost and some sort of legal precedent was created where then sort of the Blanch memo isn't as relevant anymore because now the legal precedent has been created. You don't think that that was the case at all?
I don't think so. I mean, think about the policy behind the Blanch memo. The Blanch memo is meant to create regulatory clarity for the digital asset industry and for Bitcoin, and it is meant to end regulation by enforcement and especially regulation by criminal prosecution. This now obvious regulation by criminal prosecution, obvious because of the recent Brady disclosure, is going on in the Trump administration. It's happening now, right? It's not a past thing, it's a now thing. And then, beyond the sort of unfairness to the individual defendants in this case, who are facing years, if not decades, in prison, right? The money laundering charge can come with really harsh penalties. The precedent goes way beyond the individual defendants in this case, right? If a court were to rule that the Bank Secrecy Act, now the court can be the final authority on this, because remember our three parts of the United States government, the three branches, the federal courts can decide, right, that the Bank Secrecy Act does not require control or custody of funds. I think that would be a grave error. But if a judge were to do that, like Judge Fela sort of did in the motion to dismiss in the Tornado Cash case, that would be incredibly damaging and I think just very, straightforwardly contrary to what the administration wants to do, as spelled out in the Blanch memo, also as spelled out in several of the president's executive orders, where he talks about Americans' right to lawfully use blockchain technology and for developers to not be punished for writing code.
Okay. So when it comes to this, so there's going to be some sort of, we have something that will come out of this. Will that have a direct effect on the Tornado Cash case? Do you think it's inevitable that if the Samourai, if these charges are dropped, that the Tornado Cash case is to follow in the same pattern?
So it's not inevitable, but my guess is that both cases will have the same outcome. Now, notably, my understanding in the Tornado Cash case is that the defense attorneys in that case asked for, I think they asked as discovery, maybe instead of Brady material, but they asked, did the prosecutors have any discussion with FinCEN? And the prosecutor said, we don't want to tell you. And the judge in that case ruled, actually, the defense is not entitled to that information. Notably, in the motion to dismiss, so that case is further along. In a criminal case, the judge decides issues of law, and then a jury decides issues of fact. So before you have a criminal trial, you have various motions or pleading. And the big one here is motion to dismiss, where you say to the judge, listen, even if we accept all of the facts that are alleged here as true, this isn't a crime because of X, Y, and Z. And critically in these cases, the argument is this is not a crime because it can't be money transmission if you don't have custody or control over user funds. And the government never alleges that the defendants had custody or control of user funds. So the motion to dismiss already happened in the Tornado Cash. The defendants lost, and Judge Fela ruled that the Bank Secrecy Act doesn't require control. But a central piece of the briefing in that case, of the government's argument, is they looked at the 2019 guidance and they argued repeatedly with a straight face that under the 2019 guidance, under the way FinCEN looks at this, the Bank Secrecy Act does not require custody or control of funds to apply. And it turns out that was wrong. So the question is, did the prosecutors in Tornado Cash know this? Because we knew the prosecutors at that same time in Samourai Wallet knew it. And did they make this argument anyway? Did they essentially lie to the judge or mislead the judge in some way about what they understood the guidance to mean? Or did they not know because the Southern District of New York, right, the U.S. Attorney's Office, didn't share information between two prosecution teams that were bringing essentially the same very novel legal theory? Both of those seem really bad. And so if I were Judge Fela, notwithstanding my earlier order about discovery, this is something I would be very curious about and take pretty seriously if the prosecutors knew that they were in some way misrepresenting what the guidance meant and the guidance said.
Okay. This feels like a little bit of a stain on the SDNY, the Southern District of New York, which, tends to be very buttoned up, takes pride in justice being served. Does this seem, just generally speaking, sort of like an outside of the ordinary sort of situation in the Southern District?
Yeah, yes and no. So, I mean, the Southern District of New York is an institution, right? It is the most well-known, the most prestigious federal prosecutor's office. I personally have friends who work there. I have family who work there. I worked in the court there in the Southern District of New York, and I think that the attorneys, by and large, are the smartest young lawyers out there who work for the government. And they do a lot of good work, and they are buttoned up, and they generally are very smart. Now, they also have a bit of a reputation of being very expansive in terms of their jurisdiction, right? There is a nickname for them called the Sovereign District of New York. Anyone who's seen the show Billions is familiar with this approach. And so in some ways, it's not unprecedented for them to take a wide view of what is their jurisdiction, what types of cases they can bring. However, I think that is a completely different matter than regulation by criminal prosecution, right? Like the Constitution, right? Basic principles of fairness and due process mean that you can't charge someone for a crime that they really had no business knowing was a crime. And that just seems to obviously be the case here in both the Samurai Wallet and Tornado Cash cases. So I really don't think there's an excuse for that. And I think that is a stain. And then this withholding this Brady information for a year, I think also there's just no excuse for that. And, that, in my view, really just should end the case.
Okay. In the Netherlands, so I think the Tornado Cash case is getting tried there as well. And I believe the judge, I forget if it was a ruling, but the judge said something along the lines of, well, you knew that bad people could use this technology and you deployed it anyway. Could any of that be applied here? Or is that just...
No, no. I mean, that makes me frightened for people who live in the Netherlands about but our First Amendment would make it impossible to make the same arguments they made in that case. They said if you publish code and it was foreseeable that people would use that code for bad means, and you didn't find some way to engineer the code such that you could stop it, essentially you're on the hook. And as I think lawless as these prosecutions have become in the United States, that wouldn't even pass the laugh test in court.
Okay. Where do we go from here? What does the timeline look like in your mind? What does an ideal timeline look like in your mind?
So the defense counsel here is asking the judge to have a status meeting so the government can discuss the circumstances of when they knew this, why they didn't disclose it, and where to go next. So that'll be a very interesting hearing. I will absolutely do my best to be there because I think that'll be pretty fascinating to watch. In the meantime, the government might respond, right? They might have their version of the facts that they will put on the docket. So we might see something in writing before there's a live hearing, or the government just might say, great, let's do this hearing, and then it'll happen in court. In the meantime, the government is still deciding whether they can bring this case under the Blanch memo or whether they should drop this case because it's inconsistent with the Department of Justice's stated theory. And so I wonder if it'll have any impact on that. And then, after the status hearing, we'll see what the judge says, what remedies the judge wants to impose for this 5F violation, if any. And then we'll also see if Main Justice gets involved, if the administration gets involved to stop what they see as prosecutions outside of their mandate.
Could you touch on that a little bit more? So if the administration gets involved, so could you explain that a little bit? Prosecutions outside of their mandate, so they could just simply say that because the Southern District is sort of a derivative of their power, well, not a derivative, a branch or branch of their power, they can step in. What level of authority can they have in that sort of situation?
Yeah, so this is a really big question right now in American government, right? So typically, U.S. Attorney's Office have a lot of latitude to, the U.S. Attorney can bring what cases. What are called line prosecutors, the people who actually prosecute the cases, the assistant U.S. attorneys are the ones who are the lawyers who try those cases. And traditionally, there's a lot of independence given there. Now, that being said, the U.S. Attorney's Office are part of the Department of Justice, which is part of the executive branch, which answers to the president. And even in a pre-Trump 2.0 administration, typically there is policy that guides what types of cases U.S. Attorney's offices are going to bring. So it's not completely immune from political considerations. And this is definitely something that a normal administration would consider. Now, in Trump 2.0, the administration is very consciously taking a strong view of executive power, sometimes called the unified executive theory or the unitary executive theory, that says all of the authority under Article 2 of the Constitution, the entirety of the executive branch, answers to the president. And therefore, there shouldn't be any decision makers, right? Whether they're in the agencies, the departments, what have you. The Fed is a big one, that don't do what the president wants them to do. And there really shouldn't be this independence because the only actor in the executive branch who is democratically elected is the president, right? The president is the representative of the people. And therefore, in order for our Constitution to work in a democratic fashion, the president actually needs to have authority over what the executive branch does rather than unelected bureaucrats. So that's been a live issue across the executive branch, and I think very much applies here. So especially in light of that environment, if I'm the White House, right, if I'm Bo Hines, if I'm David Sachs, and especially if I'm Todd Blanch at the Department of Justice, where I clearly laid out, here's what I think the right thing to do is, and here's what the department is going to do going forward, and here's what we're not going to do going forward. And not only are these prosecutors not dropping these cases that threaten to set incredibly damaging and unfair and illogical precedent for the digital asset industry, but they were hiding exculpatory evidence for a year when they knew that the theory they were bringing, the legal theory that they were trying to use to put people in prison, was inconsistent with what the expert part of the administration, right, the part of the Treasury that they're alleging, the defense didn't get a license with. I would see that completely as a slap in the face. And I would think this is an appropriate instance in which to intervene, rather than letting this sort of Biden-era prosecution keep going that really feels in some ways, whether or not it was intentionally to hurt crypto, it really feels more like a hangover from the Operation Choke Point 2.0 era, from the Gensler era, from the Warren era, than it feels like something that belongs in this administration.
Okay. Do the Samurai devs have any recourse here? They've now been under house arrest for about a year or so. I think this whole process, I think you mentioned, started in August 2023. This is almost 2 years long at this point. Can they come back and then sue the government for what they've been put through at this point? Not that that's the most important thing to happen here, but it really does seem unfair to them if,
So they may be able to down the road, but I think that's a few steps. Now, their more immediate recourse is this 5F violation that we talked about, where in not disclosing this Brady material, it really looks like the prosecutors violated the court's rules. And in the letter that the defense wrote today, this Brady letter that we're talking about, the defense lawyers point out that the defendants have already been harmed by this violation in a couple of ways. One, the likelihood of the government's success is a relevant factor in bail. And one of the defendants, Keone, has been under house arrest for a year now, where the decision that he had to be under house arrest was, at least in part, based on the likelihood of success in this case, which is in large part based on whether FinCEN viewed what they did as money transmission or not. So that seems incredibly relevant to the bail decision that already happened. Also, the most difficult, going into the motion to dismiss, which is the next big phase in this case, the most difficult precedent out there is the Tornado Cash decision, where Judge Fela, who's the judge in the Tornado Cash case, denied the motion to dismiss there, finding in part that under the guidance, the guidance didn't require control or custody for money transmission. That, I think in all likelihood, if we'd known this earlier, would have gone the other way. And so, facing that seems to have already harmed the defendants. So, if I were the judge in this case, if I were Judge Berman, that is definitely something I would keep in mind. And, he has very wide latitude to impose remedies here. And so I think that is the more immediate recourse for the defendants. And then, if and when this case finally goes away, I'm sure they'll give a long, hard look at what civil cases they could bring against the government for being, treated in this way.
Yeah, super interesting. Do you have any insight as to who brought these cases or this idea of the government going after people devs creating mixing services to the attention of the Deputy Attorney General Blanch? Do you have any insights into that? I'm curious as to why this was a priority to him, why he put this memo out in April.
Yeah, so I think it's a couple of things. One big factor is the Bitcoin community as a whole and the crypto community as a whole. People have been loud about this, and that's been great. It's been really incredibly heartening to see the sort of grassroots support. I think the Trump campaign heard that loud and clear, and they feel that this is a campaign promise they want to deliver on. So I think that is one big piece of it. Another big piece of it is our allies on Capitol Hill have been loud about this topic. At the outset of the Samourai Wallet case, there was a letter from bipartisan senators, Ron Wyden from Oregon and Cynthia Lummis from Wyoming, saying that the DOJ, writing to Merrick Garland, they need to drop these cases, that this is unfair, that this is regulation by criminal prosecution. I think that was helpful in drawing attention to the current administration. And then I also think some of the staffing that's happened now, they're getting people in the executive branch who understand Bitcoin and crypto and who don't see it as the enemy. So when they're looking at cases, when they're deciding what their policy should be, and then when they're looking at President Trump's executive order to make America a haven for Bitcoin and crypto, and they're trying to operationalize that, I think they have folks who know what that means, and they know where sort of the weak points are. And certainly Tornado Cash and Samurai are, in my view, just definitely the biggest weak points we have left on the table.
Okay. one of the things that still comes to mind is that the government will find some other way, or some bureaucrats will find some other way to go after mixing services or something along those lines. I remember sitting behind the former CFTC chair, Tim Massad, in a Senate Banking Subcommittee hearing talking about digital assets, and he just didn't like this idea of these bearer assets moving around without knowing who owned what. Obviously, a crypto mixer would only exacerbate that sort of thing, would make it harder for people to determine that. Do you feel like there's going to be another attack from some other angle that maybe we're not considering right now?
Yes, on a long enough time horizon, just definitely yes. I mean, I've sometimes used this line, the sort of work I do with BPI and policy, and the work I do specifically with the Peer-to-Peer Rights Foundation with cases like this. I think it's important work. That's why I do it. But at the end of the day, it's a rear guard action, right? Ultimately, what this technology is about, what Satoshi invented in the white paper and with blockchain, it's a powerful revolution. I think it is good for the world. I think it's brilliant. But ultimately, it does take power from the state, right? It takes power from the state about the issuance of money. It takes power from the state about censoring transactions. And I don't think that the state, whether here in the United States or especially abroad in more authoritarian countries, is going to take that lying down. And so eventually there's going to be a confrontation. And so the ultimate resolution here is for people to build unstoppable technology like Satoshi did to provide privacy that can support all of the people who need it, whether they're human rights advocates, whether they're people who want to, spend Bitcoin or stablecoins without revealing, all of the other payments they've made, all of their private information, their net worth, et cetera, et cetera. Like, we need people to build those tools, and so we're buying time. Now, getting rid of these cases, the Blanch memo already was a terrific step in the right direction. Getting id of these cases would be a huge step in the right direction. I really sincerely hope that happens. And then there are other more durable steps we can take. So first, I really think FinCEN, it seems they thought the 2019 guidance was clear that there is this line of custody and control for when the Bank Secrecy Act applies. But just in case, another judge gets the wrong idea about this, it would be great if FinCEN updated their 2019 guidance to 2025 guidance, where they go into all of the new technologies, right? Some things that weren't really around in 2019. For example, federated Xiaomi and eCash mints, right? Lightning routing nodes, things that we really do need protection for that are, we understand to be non-custodial and critical to the sort of Bitcoin ecosystem. Those should be protected, and FinCEN should put out clear guidance that doesn't leave any room for misinterpretation, even by prosecutors who should know better. And then the best step we can take in this direction, the most durable thing we can do in the law, is to actually pass a law to exempt non-custodial tools from the Bank Secrecy Act. And the current leading contender for that is called the Blockchain Regulatory Certainty Act. And we very much hope that that will get passed. It's taken a little bit of a backseat to the legislative priorities like stablecoins and like market structure that have a huge amount of industry money behind them. But in my view, it's just clearly more important than both of those things. If Bitcoin and crypto technology is going to be useful, it's going to be useful specifically because it allows disintermediated peer-to-peer transactions, right? Where you can use a decentralized exchange where people can swap assets in a trustless way, where you can spend privately and know that you're not trusting someone to hold your funds for you, right? Where you can self-custody assets in software that is not going to spy on you. I think the value, right? The market cap of Bitcoin, the reason Bitcoin is digital gold is downstream of that. So we need to protect that if this is going to ultimately work. I would definitely encourage folks who are listening to this, talk to your congressman, talk to your senator, and really try and throw your support behind the Blockchain Regulatory Certainty Act, which is the most permanent solution we can have, short of some cypherpunk technology that actually can't be regulated out of existence.
Okay. Anything to add to that call to action? Is time of the essence right now? Should people be getting loud immediately to try to keep the momentum that might have come with this announcement today, this bombshell revelation?
Yeah, I mean, yes. Now is 100% the moment on this. I think our clearest appeal right now is to the Trump administration and specifically the Department of Justice. I've said several times in this conversation, but I really do think this is a situation where they should intervene. I really do understand the merits of prosecutorial discretion and independence, and I understand why U.S. attorneys' offices in general should have latitude to make their own decisions. But clearly, the prosecutors in this case abused that discretion, right? They what they did was unfair. It's going to set bad case law. It's unfair to the defendants. It's unfair to the industry. I don't know what's taking them a month to decide whether it's consistent or not with a memo that looks to me designed to stop exactly this case. By and large, the administration has been very friendly to Bitcoiners. We've been, by and large, pretty friendly to the administration. And if ever there were a time to call in a favor, I really think this is it. And I think, let your voice be heard on social media. Write to, again, your representatives who can talk to the administration. Make sure that they know that this is a case that Bitcoiners care about, that this is foundational to making America a Bitcoin superpower, a place that is a haven for Bitcoin, a place where we're going to thrive, and we're going to see a version of Bitcoin that is consistent with American values of private property and freedom of speech and association and all of these things, as opposed to something that is just captured by financial institutions, or even worse, is forced to add features like a authoritarian CBDC. I try and be pretty measured about things, but I think really this is the moment to go for it.
Yeah, I appreciate that. Is there anything else we didn't touch on that you wanted to mention? I mean, that seems like as good a place as any to end, but just want to give you that space.
I think that about covers it.
Sounds good. Well, Zach, thank you so much for taking the time to do this.
Thank you so much as well.
Our pleasure. Thank you, everybody, for watching. We'll talk soon.